Phil Holloway, former assistant district attorney, retired U.S. Navy, former police officer, and legal advisor to the Georgia Sheriff's Department, joins me now. Thank you, Phil, for talking to us. First of all, the president here getting involved in any of the subpoenaing and all of the research that needs to be done by these committees is certainly meddling, but is it an impeachable offense?
Well, great to be with you, Julie. Listen, when you find yourself in a hole, the first thing that you've got to do is you've got to stop digging, okay? Whether or not being remotely involved in any capacity with Hunter Biden and his decision to defy that subpoena, whether or not that's an impeachable offense, of course, is something that's left squarely to the wisdom, if you will, of the House of Representatives. I doubt it's going to make it that far, but it was stupid for Hunter Biden to defy that subpoena. It was certainly stupid of him to go on the Capitol grounds and proverbially give the middle finger to Congress on the day he was supposed to be in there testifying. It was stupid, in my opinion, for his lawyer to be standing there with him while he was doing it. And it was stupid if his father had any connection with it or any role in that whatsoever. Presumably, both of these Bidens, Joe and Hunter, are trained as lawyers, and they know that the best thing to do is to keep your mouth shut. And at this point, whether or not Joe Biden is involved with his son's legal affairs seems to be something that would just be an automatic no-brainer for the president to just steer clear. But he can't do it because he just doesn't, I think, have the good judgment to avoid everything that involves Hunter and his legal problems.
In the letter sent by the House Oversight and Judiciary, the chairman, they basically asked the White House counsel and accused the White House counsel, but most specifically, they accused the president, obviously, in this letter that Mr. President corruptly sought to influence or obstruct the committee's proceeding by preventing, discouraging, or dissuading his son from complying with the committee's subpoena. That's obstruction of justice. That is a serious offense, is it not? And if you're the president, do you get away with that? Is obstruction of justice no big deal if you were the president of the United States?
Well, the devil's going to be in the details. If the president merely knew of what his son was going to say and didn't have anything to do with creating that response or causing that response, that's probably not going to be enough to trigger any kind of legal problems. But it's a political issue more than anything, because the House of Representatives decides what is impeachable and what's not. Now, people don't like that standard, but it is what the Constitution gives us. It's very loose, it's ill-defined, and it's something that's left squarely to the body politic and not the lawyers and the courts, although it's clothed in the sense of legality. But the president needs to understand that there is an official inquiry, an impeachment inquiry going on, and
he should be advising his son to cooperate.
From Hunter, the better.
I mean, if he's such a doting father, if my child was in trouble, I'd just be like, cooperate, just cooperate. And so I don't understand why Hunter Biden would decide to ditch his deposition. I mean, if you aren't the president's son and you ditch your deposition, don't you think you're going to get some slap back? It seems that because he is the president's son, skipping a deposition is no big deal. I'm going to move on to the Michigan Supreme Court, because that was a big story that came out yesterday when it rejected a move to kick former President Trump off of the 2024 primary ballot. And this, as you know, comes 1 week after the Colorado Supreme Court decided to disqualify Trump from their state's primary ballot. The Colorado Republican primary, that party, has officially appealed that decision to the U.S. Supreme Court. So now we're waiting for the U.S. Supreme Court to weigh in. And in the meantime, former President Trump has praised Michigan's ruling, and he writes this: the state Supreme Court has strongly and rightfully denied the desperate Democrat attempt to take the leading candidate in the 2024 presidential election, me, off the ballot. There are still more than a dozen states, by the way, considering petitions to keep Trump's name off of the ballot. So, with that said, Phil, you know, the Michigan Court of Claims judge who first got the case, he said that state law in Michigan doesn't give officials any leeway to police the eligibility of presidential primary candidates. That he also said that the case raised a political question that shouldn't be decided in the courts. Of course, in the state of Colorado, the law is a little differently. But now, with the nation's primaries right around the corner, do you think they're going to weigh in these two decisions? Because now we don't just have Colorado, we've got Michigan. That might put more pressure on the Supreme Court to come out with a decision sooner than later. Would you
Yeah,
agree?
well, the Supreme Court has to do something, I think, very quickly by its own terms. The opinion in Colorado, the stay is in place only until January the 5th. So this is going to need to be something that's dealt with very quickly. The Colorado opinion, it was 4-3. 3 of the justices basically said what Michigan said, and I think they got it right. Listen, the insurrection clause of the 14th Amendment was designed to keep Confederate loyalists from being seated in Congress following the Civil War, because many of them got elected. They went to Washington, and the Congress was able to refuse to seat them based on this. The courts throughout the United States, in the various states, the election laws are not equipped to adjudicate whether someone has committed an insurrection within the definition, whatever that may be, of the 14th Amendment insurrection clause. This is nothing more, whether you like Trump or hate Trump, you need to understand this is nothing more than a liberal fantasy, which is basically about killing Trump's political career once and for all by keeping him off the ballot. And the idea is if they can get him off the ballot in enough states, and there's a lot of even red or maybe purple states that have left-leaning Supreme Courts. So the fantasy idea is that they can just keep Trump off the ballots. But the Michigan courts are correct. This is something that the voters need to decide, not the electoral laws of the individual states.
And by the way, the Colorado GOP actually officially filed their appeal today. So that is on pause as of right now. His name will be on the primary ballot. We're going to have to wait and see how the Supreme Court decides and see how this appeal falls. So anyway, thank you very much, Phil Holloway. Appreciate you coming on. Thank you.
Great to be with you.
Hey everyone, I'm Emily Campagno. Catch me and my co-hosts Harris Faulkner and Kaylee McEnany on Outnumbered every weekday at 12 p.m. Eastern, or set your DVR. Also, don't forget to subscribe to the Fox News YouTube page for daily highlights.